you a basic idea about our second moot court problem, the moot court problem which was given to you 2 weeks back. I'm sure you must have gone through it. In this lecture, I will discuss with you all the fact of the problem, the area of law where you need to focus on. I will also talk to you about a few important cases related to the moot problem, which will further lead you to more authorities in this area. Okay, so this will help you with your preliminary research. Now, before I get to the moot problem, I would want all of you to go through two important articles of the Constitution, that is Article 15 and 16. Read those articles and understand what it is. Okay. Besides, these articles must have been extensively dealt with in your constitutional law paper, right? So you all are familiar with the articles 15 and 16, but still we will need to brush up with them before we begin with the moot problem. Article 15 and Article 16 of the Constitution, you all are aware, comes under Part 3 of the Constitution, dealing with fundamental rights. So it's very important. Article 15 talks about prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. So if you look at this slide 2, I have highlighted clause 4 and 5. I have highlighted these two because these clauses directly pertains to our moot problem. Okay, so before we read the problem, we need to know at least what is in it. So that's why we will actually read the clauses. So 4 says that nothing in this article or in clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes and the scheduled tribes. That means state can make provisions for the socially and educationally backward classes of citizens. Now what does 5 say? 5 says that nothing in this article or subclause G of clause 1 or of Article 19 shall prevent the state from making any special provisos by law for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes or the scheduled tribes insofar as special provisions relate to their admission to educational institutions, including private educational institutions, whether aided by the state, other than the minority educational institutions referred to in clause 1 of Article 30. So you see that this particular special provision is with regard to admission to educational institutions. Article 16 in slide 3. Article 16 talks about equality of opportunity in matters of public employment. That means there shall be no discrimination, there shall be equality of opportunity. However, you will find that the clause highlighted, clause 4, it talks about a special provision with regard to reservation of appointments or posts in favor of any backward classes of citizens, which in the opinion of the state is not adequately represented in the services under the state. Now, I'm sure you must have gone through the equality provision extensively in your constitutional law chapter, where you have dealt with the equality among equals. Okay, so there has to be no confusion here, because in clause 1 you will find that there shall be equality. Again in clause 4 you will see that we are talking about special provision or reservation for some particular class of people. Okay, so understand equality in those terms. Besides, see the similarity and also dissimilarity between 15 and 16. Article 15 talks about provision, again special provision for the advancement of socially and educationally backward classes of citizens, and clause 5 again specifically includes educational institution, admission to educational institutions. Again in 16 you will find the same thing, special provision for reservation of appointments or posts in favor of backward classes of citizens, and this pertains to services, that is employment. Now if you want to further enhance your knowledge, enrich yourself with regard to this very interesting reservation policy and the provision that we have in our constitution, you can look into CADs, okay, constitutional amendment debates. These are the books that's available in the library, and you'll find some access on the internet as well, where you will see that the champion of reservation, Dr. B.R. Ambedkar, when this particular article was given before the parliament, put forward in the parliament, has given a very good debate on the necessity of reservation. You will also find counter from Mahatma Gandhi, Mohandas Karamchand Gandhi, his deliberation on this subject as well. You will find a sort of a very interesting debate between the two. So you can go in that direction as well. Okay. Now that we have gone through Article 15 and 16, we are now ready to read and understand Moot Problem 2. If you see slide 4 before you, the Moot Problem, the important aspects of Moot Problem has been given before you. Moot Problem 2 begins with 124th Constitutional Amendment Bill, which was introduced in the Parliament, which was passed by the Parliament, both the houses of the Parliament, and on 12th January 2019, it even received the assent of the Honorable President and was published in the Gazette on the same day. And hence we have the 103rd Amendment Act 2019. So this is done. Now we need to know what amendment, what change was brought by virtue of this Amendment Act. If you look below in the same slide, two important clauses were inserted by virtue of this Amendment Act. What were these two important clauses? Firstly, it was inserted in Article 15 and Article 16. So by now we are clear about Article 15 and 16. So let's see what additional part has been done by this Amendment Act. Clause 6 was inserted by this Amendment Act, and Clause 6 gives the special provisions for advancement of economically weaker sections of citizens other than the classes mentioned in Clauses 4 and 5. Now, if you remember the classes mentioned in 4 and 5, you can even go back to the Article 15 given. 4 and 5 talks about educationally, socially and educationally backward classes of citizens for the schedule and for the scheduled caste and the scheduled tribe. So, other than them, there is another class, that is the economically weaker sections of the citizens. So for them, special provisions has been mentioned by virtue of this clause. And also, if you go through in the bullet points, you will not find the details, but do go through the Moot Problem. There is an extensive clause. So 6 further says that it would be 10% in addition to the existing reservation. So whatever reservation is given in 4 and 5, now in addition to that, 10% will be given for economically weaker sections of the citizens. Okay, so now the next insertion which was done by this amendment is clause 6 of Article 16. This is again the same thing, reservation, but with regard to appointments or posts in favor of, again, economically weaker sections of the citizens. Again, other than the classes mentioned in clause 4. Other than the clauses mentioned in clause 4 of the Article 16. Clause 4 had made a mention with regard to backward classes of citizens, if you remember. Now, other than them, again, there is a new class, that is economically weaker sections of the citizens. So here that reservation has been done, that change or that amendment has been done by this particular Amendment Act. Let's come to slide 5. After the amendment was made, Mr. X challenged this constitutional amendment, challenged the constitutional validity of this amendment before the Honorable Supreme Court of India, and certain issues have been framed before you, and for these issues you need to research. So let's understand what are those issues. The first issue, whether 103rd Constitutional Amendment Act 2013 violates any of the basic structure of the Constitution of India. Now for this we need to know what basic structure means. If you remember the amendment chapter which was done in the Constitution, there is a mention of basic structure. By the end of this lecture, I will also discuss basic structure with you. Okay, so no need to worry about that. So first issue was whether this particular amendment which brought about these special provisions, whether this violates the basic structure of the Constitution of India. Second, whether the additional 10% reservation, that means, I hope you remember when we mentioned the special provision introduced by this particular amendment, 10% reservation besides the existing reservation, that means which was already given to the backward classes. So 10% reservation for economically weaker section in educational institutions and public employment is unconstitutional, as it breaches and exceeds 50% limit for reservation as laid down in Indira Sahani versus Union of India. Now, Indira Sahani, I had asked you all to go through this case because of this particular reason. Indira Sahani case talks about reservation plus a reservation limit. So here the issue is whether this additional 10% that is being created, whether it breaches this particular 50% limit or not. Okay, so we will also discuss Indira Sahani in some time. Finally, the third issue here is whether reservations under the constitutional scheme can be prescribed only on the basis of economic criteria. So because this 10% was reservation was done for economically weaker section, right? So whether this can be done or not, excluding social and educational backwardness also. So this is the third issue. So these are the three issues on which you need to deliberate upon, research upon, and then give me your arguments. Okay. Now we come to slide number 6. Slide number 6, you will get an idea on Indira Sahani versus Union of India. You all have already submitted your synopsis on this case. So Indira Sahani, why Indira Sahani? Because in this particular moot problem, the issue number 2 deals with a decision given in Indira Sahani. So apparently, if you look at issue number 2, apparently it is seen that Indira Sahani case, a reservation limit was given, that 50% is the limit for reservation. Okay, beyond that there has to be no reservation. 50% is the limit, and the issue here is in this matter is that 10% extra reservation which was given to economically weaker section, this is in total breach of the reservation limit which was given in Indira Sahani versus Union of India. Okay, so this was the issue. This is the issue here for you all to deal with in the second issue for the moot problem, that whether or not it is breaching this limit or not. Okay, so for that let's understand Indira Sahani case. Indira Sahani case, if you see, before you get into the fact of the case, there is a little background, very interesting background. You will see the dynamics of the political scenario in the country then, okay, and the changes brought forth in the legislation. Okay, so and various executive orders as well. Okay, so firstly, let's go back to 1979. 1979, the government was headed by the Prime Minister Shri Morarji Desai, and Morarji Desai appointed a Backward Classes Commission headed by BP Mandal. So this is also known as the Mandal case. Okay, this particular case is also known as Mandal case, and this commission was also known as Mandal Commission. So once this was appointed, this was actually appointed to investigate on the socially, economically backward classes within the territory of India. You know, how many backward classes are there in the country, suggest some steps for their advancement. So for this matter, this commission was appointed. Now once this was done, the commission now accordingly submitted its report the following year in the 1980. Now what happened was, according to this particular report, it identified some 3,743 castes as socially and educationally backward classes, and it also recommended that there has to be certain reservation for these classes of people, and it prescribed 27% government jobs for them. Okay, so this was a mere suggestion at this point of time, suggestion given by the commission. Now in the meantime, the Janata government now collapsed. So now a new party came into power, that is the Congress party. Then thereafter the Congress party did not implement, obviously it is the opposition, so it did not implement the Mandal Commission report. Now again in 1989, the Congress party again was defeated, and Janata Dal government again came into power. Now when it has come into power, the government of India, now with the Janata Dal government, issued the office memoranda. Now it wanted to implement that suggestion given by the recommendation given by the Mandal Commission. So office memoranda was issued in 1990, which prescribed 27% seats for backward classes in government services. Okay, so this was the office memoranda. Now when this was done, there was a huge violent anti-reservation movement in the nation. So what happened was, it was also followed by a writ petition which was against this office memoranda, challenging this validity of office memoranda, and this was done on behalf of Supreme Court Bar Association. This particular writ petition was meant for staying its operation, for the stay order. So the 5 judges bench of the court stayed the operation till the final disposal of the matter. So meanwhile, what happened was, unfortunately, Janata government again collapsed, and in 1991 again the parliamentary elections, the Congress party came into power at the center. The Congress party now, with Sri P.V. Narasimha Rao, issued another office memoranda. So you will see September 25th, 1991 highlighted, issued another office memoranda, but it made 2 changes in the existing one. Okay, so those 2 changes were, number 1, it introduced economic criteria. That means it granted reservation by giving preference to the poorer sections of the socially and educationally backward classes in the 27% quota, and reserved another 10% of vacancies for the socially and educationally backward, economically backward sections of higher castes. So these 2 changes were made by the Congress government. The economic criteria, now you will see that it was introduced here at this point of time. Okay. Now the 5 judges bench, the matter was still in the court, so 5 judges bench referred the matter to special constitutional bench of 9 judges. Now the 9 judges bench, the decision, the 9 judges bench, constitution bench of the Supreme Court, by 6-3 majority, okay, came up with a decision. So what was the decision? We will look into it now. Let's come to the decision of the case. Remember, students, I have given you an elaborate judgment in Indra Sahani's case on your WhatsApp. Do go through it. Okay, this is just basic information with regard to the decision. So let's go through it one by one so that it's clear for all of you what was the decision given in this case. Firstly, the decision of the union government to reserve 27% for the backward classes, this was the thing which was challenged in the first place, right? So whatever was challenged, it was decided that it is constitutionally valid. Okay, but additional information which was given, additional explanation which was given, that this backward classes should not exclude, should not include the creamy layer. So creamy layer will be excluded. So if you go to the judgment again, what is creamy layer? All those those belonging to the civil services, parents belonging to the civil services, all those details have been given in the judgment. Okay, so firstly, the 27% reservation was held as constitutionally valid. Second, the reservation which was given, a limit has been prescribed. So here this is something which was reflected in the issue as well, that 50% limit has been given, so such reservation shall not exceed 50%. Next, the office memorandum which was issued, the two office memorandum 1990 and 1991, they were held partially valid. This is again the same thing as the first point, partially valid in the sense that the reservation is correct, but creamy layer should be excluded. Okay, so if you look into the couple of years back in the High Court of Sikkim as well, this issue of creamy layer came about when the state civil services examinations had taken place. Okay, and some a particular candidate of a backward class category secured the particular position. Okay, but in this matter she got through the reservation. Now it was challenged in the High Court of Sikkim because she belonged to the creamy layer category. Okay, so you can follow that up as well. So it was again the same reference was made, the reference to the same case was made, and it was held that yes, she belongs to the creamy layer category, so hence she is not entitled to claim the backward classes reservation category. So you can look that up as well if you want to relate it to the state cases. Next, it was this decision struck down Congress government's office memorandum reserving 10% government jobs for economically backward classes among higher classes. If you remember, there were two additional, or you can say two changes which were made in the subsequent memorandum, right? So one of the changes was that 10% reservation should be made to the economically backward classes among higher classes. So that particular change which was done in the office memorandum, this was striked out. Then another peculiar feature of this judgment is the reservation which was accorded to the 27% to the backward classes is with regard to appointment, and it shall not be applicable to promotions. So this is the gist of the judgment. This is the decision of the court with regard to Indra Sahani. So slide number 8, I have given you 103rd Constitutional Amendment Act 2019. The notified gazette, notified publication will also be sent to you on your WhatsApp. Okay, so you can go through that as well. Anyway, you will see in front of you the two clauses which was inserted by virtue of this amendment, that is clause 6 in Article 15, Clause 6 in Article 16. So this is the act, remember, this is the act which was challenged. This is the Amendment Act. Now what it did was inserted Clause 6, which gave special provision for advancement of any economically weaker sections of the society other than the classes mentioned in Clause 4 and 5. 4 and 5 mentioned backward classes, right? So economically weaker sections of the citizens. Now if you reflect back to Indira Sahani case, economically weaker section was introduced in the second office memorandum, and you will now have to check the judgment, go through the issues, go through the arguments from both the sides, for whichever side you are representing. So go through the arguments given from both the sides in the judgment. There you will find some points, okay, with regard to introduction of economically weaker sections of the citizens. Decision we have already discussed that it was not allowed, right? The economically weaker section, 10% reservation was not given in the Indira Sahani case. Similarly, in Article 16 as well, it is for the reservation of appointment in posts, again for economically weaker sections of the society. So here you have it, the Constitutional Amendment Act which was challenged before the court. We have come to the final slide, and what we have discussed in this short lecture today is the moot problem. Number one, understanding the moot problem. Second, we have tried to identify the area of law. Okay, we went through the constitutional provisions, relevant provisions. We have tried to understand that particular area of law. Third, we have identified authorities in the area of law. That means we now know where to look and from where do we start our research. So with regard to issue number 2 and 3, you can look up these authorities. And keeping in mind the lockdown period and the limited material that you have in hand, you can confine your research and arguments within these authorities. Besides this, I have also listed in your final slide some important reads. So these are ongoing petitions on the same area, the amendment of 2019. So you can look that up as well. I will also forward you a copy of the petition where you will get some information on that. Do check in some links. I have forwarded you a link. There are others as well. You can look into other links as well. I have just sent you one here. So this is from the Hindu, 31st July, so you can check that link out as well. So for issue number 1 and understanding basic structure, you can go through the amendment chapter that I have forwarded in the WhatsApp previously. So do check it out. That has elaborately discussed basic structure. And those who have not received it, do let me know so that I can forward the basic structure chapter as well. And if you still wish to get more clarification on this area, then I will also send another presentation on that, on the issue number 1, that is basic structure. Okay, so work on your research and stay indoors and